What are some of the gotchas that we will typically see when we're negotiating SaaS contracts? That's what I want to talk about today. My name is Marcus Harris. I'm a software and technology attorney. For over 20 years, I've drafted and negotiated a variety of technology-related contracts and litigated failed ERP projects in courts across the country. One of the first issues that we see when we're negotiating SaaS contracts is really clients that have not done enough preparation for the negotiation process. They don't start early enough. How much time do you really need to negotiate one of these agreements? Well, I think it depends. It depends on the size of the agreement. It depends on the risk profile of the particular technology. It depends on the vendor that you're dealing with, and it depends on how much money you're spending. But at a minimum, I think you'd probably want 60 days to negotiate one of these agreements. If it's going to be a large enterprise deal, you're going to want much more time. It just depends on the deal, but you don't want to rush this process. You want to take a reasoned review and analysis of these agreements. You want to discuss them with counsel. You want to have a strategy for dealing with the software vendor. You want to distill down what the concessions are that you're going to ask for. You want to have backup positions. And ideally, you'd want to be negotiating with more than one vendor at a time. There's a whole process associated with this, and it's not something that you can just jump into. I think, the mistake that many of our clients make, and it's not really their fault, it's really the unreasonable expectations that are put on them by the vendor, is that these are simple contracts. They'll put in front of you, a one-page DocuSign or a two-page document. But the reality is, as you look at that agreement, it oftentimes will reference via URLs other agreements that are more substantive. I've had a document recently that looked like a simple two-page order form that incorporated by reference, and not in a very clear way, about a 15-page contract that required massive substantive review that was incredibly one-sided, unreasonable, and onerous. And that really is what you're getting yourself into. It's not going to be as simple as you think it's going to be. The next gotcha is really clients that don't understand what their business requirements are. They don't have an understanding of what their current state is. They don't have an understanding of what their future state is going to be. And the problem with that is that they don't have an understanding of what types of functionality gaps are going to be present in that software. And where that comes out in the software negotiation process is really in a couple places. You want to have a robust user acceptance testing process. You want to understand what the deliverables are going to be. You want to make sure that the software is identified in the contract accurately, that you know what you're licensing, that it is consistent with what you think you're buying and what you think you're getting. So all of that needs to be done on the front end. In connection with the negotiation of these SaaS agreements, you really have to make an effort to understand the vendor's pricing model. I think that should go without saying, but it's not always intuitive. It doesn't always present itself in a clear way. And I think what goes hand in hand with understanding how much money you're going to spend is having an understanding of what the renewal rate is going to be when you have to renew that contract. Typically, these SaaS agreements are going to have a limited term, an initial term. It could be anywhere from 2 to 7 years on the front end. And ideally, you will have capped the vendor's ability to increase the cost of that software on a year-over-year basis, or maybe it will be capped for the duration of that initial term. But when there is a subsequent term, that vendor is going to want to increase the price and capture additional revenue. And ideally, what you want to do is incorporate into your agreement a restriction on that vendor's ability to increase the price of the software for subsequent terms. And I think you've got to be aware as you're negotiating those that they're going to want to have certain carve-outs. They're going to exclude certain pricing models. They're going to exclude certain types of products from that cap. And that can all be reasonable, but it's going to be a nuanced negotiation, and you need to know what you're getting yourself into. As far as the key provisions in these agreements that you want to look at, I think, in today's day and age, really data security comes to the forefront. You want to have an understanding of what they're going to do with your data, how they're going to treat that data, what their obligations are with respect to that data. And then you're going to want to be able to hold their feet to the fire. You're going to want to have contractual obligations with the way that they process that data, with the way that they store that data. And if something goes wrong, if there's a data incident, if there's some sort of confidentiality issue, if there's a breach, you want to be able to have substantive remedies. And typically, what remedies you're going to have, whatever remedies you're going to be able to negotiate with respect to a data incident, you're going to want to either have those damages subject to a super cap, or be carved out from any kind of cap on the liability, because I think those can be substantive damages, and it often does not make sense, depending on the size of the deal, to cap those damages at the amount of money that you spent in the 12 months preceding the issue giving rise to the claim. You want to think about scalability. You want to think about your future expansion. Again, you want to have all the flexibility built into that contract that you can, so that you're not giving that vendor the ability to extract additional fees from you as you go ahead and utilize that software in your business. You want to make sure that you've got the ability to add users at defined prices. You want to be able to swap out users, or whatever other metric is applicable. Again, it's all about flexibility and scalability and being able to think proactively on the front end, so that you minimize the likelihood that you're going to be paying exorbitant fees to that vendor for using the software the way that you need to use that software in your business. You want to focus on exit and termination clauses. You don't want to enter into any kind of a contract that you're unable to get out of. And I think that should go without saying. But in the SaaS context, vendors are very wary of giving you the ability to terminate for convenience. And the reason for that really is that they are going to provide you with some sort of discount off the list price of that software. And it's going to be based off of the length of your utilization of the software for the duration of that term. And they're not going to want you just to walk away from that obligation, and they will then be out all the revenue that they expected to generate from you. And oftentimes what you will see is some sort of a provision that will allow you to get out of that contract, but there's an acceleration clause, and all the fees that would have been due and owing for the remainder of that term are automatically, you're automatically obligated to pay those to the vendor. I think you've got to understand that. You've got to figure out ways to mitigate that and negotiate something that's reasonable and works for you. You want to pay particularly close attention to the SLAs, the service level agreement. And really what this is there should be some sort of uptime guarantees associated with your utilization of that software product. Typically it would be a 99.99% uptime guarantee with some sort of real remedy if the vendor doesn't meet that obligation. And that remedy can be, credits, it can be a refund, it can be a termination right. It depends on what it is. We would typically give a vendor, 3 bites at the apple, letting them, deviate from that uptime guarantee for a certain amount of time, maybe 3 times in a 6-month period or 3 times in a year. And if it happens a 4th time, then you've got a real remedy. You have the ability to walk away from that contract without further obligation, or you get some sort of a refund or whatever it is. And then the last thing I think you really want to think about is, in connection with the termination of that initial term or the expiration of that initial term, what kind of renewal rights do you have? What is the notification period? How do you notify the vendor that you either do not want to renew or you do want to renew? You want that process to be easy. You want to be in control of that process, and you don't want to be in a situation where you are inadvertently signed up for another 7-year term when you have no intention of continuing to use that software. I think that is going to be fundamentally problematic for you. One of the other things that you want to think about in the context of termination really is, how are you going to get your data out of that cloud system? That vendor has your data. It's on a server somewhere. It's your data. You want to be able to get it out, extract it, be able to utilize it in connection with a new product if you're deciding not to continue with that product. So these are some of the things that I think you really need to focus on as you're negotiating these SaaS agreements. Certainly not a definitive list, but something to really think about and get you pointed in the right direction. I hope you find this information useful. To the extent you have any questions about any of the issues I spoke about in this video, please feel free to reach out to me at taflaw.com. I'd love to talk to you. Thank you.